everybody, and welcome. We're going to be getting started in just a couple more minutes here. All right, we will go ahead and get started. Hi, everybody, and welcome to this Alcorn Immigration Law webinar. It is great to have you here today. Welcome to preparing your company for potential immigration compliance changes, where we're going to be taking a look at immigration, business immigration, corporate immigration, individual immigration, and all of the latest changes from this current administration with the more thorough vetting process that is underway. So today, for the next hour, I'll be presenting slides and you'll have the opportunity to ask me your questions. You can add your questions anytime in the Q&A panel. You have the option to mark yourself as an anonymous attendee, which I would encourage you to do. And I will be monitoring the Q&A panel, but only the webinar chat for logistical questions. So if you have a legal question that you'd like me to answer, please put it in the Q&A panel at any time. Now, before we get started, I do just have to do my lawyer disclaimers. So this presentation is an educational service by Alcorn Immigration Law. All information discussed should not be construed as legal advice for any specific action and is an overview only. Please be sure to consult a knowledgeable professional for assistance with your particular issue. So if you need any help, you can always reach out to us for a consultation. And the way to do that, I will have the information at the end, but the QR code on every slide is a way for you to book a consultation with us. Okay, and I can answer our first question already. Is it too late to start the H-1B process today for the current cycle? The H-1B lottery is closing on Monday. If you would like to help us, you will have to be prepared to give us all of your information from the company and the candidate today. So the best thing that you could do right now is call our office at and I'll put the number in the webinar chat for everybody so this person can be on their way and not listen to the webinar and go try to get us to help you. But the best thing is you just call us at 855-546-0015 and tell my team that on the webinar I said if you could get us everything this afternoon, we still might be able to help. So you can go ahead and do that. And otherwise, I'll be including our contact information at the end. And I see the questions coming in, so thank you. Just some other housekeeping tips. This is being recorded. We do send out a post-webinar follow-up email that includes a link to this recording, as well as the links to contact us and get in touch. So you're welcome to keep in touch, and then you can always feel free to reach out. I've had some limited capacity on my calendar this month to engage in new client consultations, but that is because we've been heads down focusing on ramping up our service quality, building out best practices, and just doing a lot of stuff on the inside so that we can hit the ground running in April and accept more clients. So we're really looking forward to that process. At Alcorn Immigration Law, our mission is to overcome borders, expand opportunity, and connect the world by practicing compassionate, creative, and cutting-edge immigration law in service of the betterment of humanity. So what we do is we help businesses and we help individuals engaging in high-skilled immigration to be able to secure visas and green cards for people who are currently anywhere in the world who want to live in any part of the United States. We've been doing this our incorporation anniversary is this September, but really I got started in the H-1B season 10 years ago, actually in my kitchen. in 2015. That was the first H-1B season I did for starting Alcorn Immigration Law out of my kitchen. Crazy times, but we've succeeded in helping almost 5,000 people from all around the world get visas and green cards, and we're excited to be able to offer that security and freedom to people to be able to live their dreams and to help companies grow and create the technologies that are changing the world and really shaping the future of humanity. So my personal background, I'm Sophie Alcorn. I'm the founder of Alcorn Immigration Law. I have a podcast you're welcome to listen to and check out. It's available on Apple Podcasts and Spotify. I go through a variety of topics. I think the episode that just came out was on perm. I have some interviews coming up with some interesting folks in and around the immigration space, immigration policy. So it's a fascinating topic that's always evolving, immigration law for tech startups. I wrote a column at TechCrunch for 4 years. It's available complimentary on our website, all of the articles. So if you ever need a quick, burst of information on how something actually works, welcome to check out the website. And why I'm doing this? Well, I'm a meditator, I'm a mom, and I just think that fundamentally we want to live in a world where every person has the opportunity to self-actualize and work in their flow state and build their dreams. And when everybody can do that, the world's going to be an amazing place to be in. And having freedom of mobility is one of those essential core human universal freedoms that's so important. And if I can help you with your immigration, then that's going to create a domino chain reaction that's going to set off a lot of good, positive things for the future. And you can always reach out to me, Sophie@alcorn.law. Our team is growing. We have a new Palo Alto office. We have a new Houston office. So we're very excited about that. We're creating a new role. This is something we haven't announced on social media yet, but it's been very exciting since we launched it. We've elevated our paralegals and legal assistants to a new role of client journey coordinator. So anytime a new client hires us, they will be assigned to an associate attorney plus a client journey coordinator to work on their case. And so the client journey coordinator is a combination of project management, paralegal, and client service to provide that dedicated point of contact so that anytime you're experiencing questions about what documents count or how to upload things, or do you need to travel? Did your job change? Did the role change? All these things routinely happen in the life cycle of an immigration case. And now we're really excited that we've innovated and we're creating this new offering. We got a spontaneous thank you letter from one of our clients for how amazing it was talking to their client journey coordinator and getting their answers right away. So we've been working really, really hard behind the scenes to, roll this out, because I think there's a lot of great things we can do for the future of, excellent legal service delivery to our clients. So we're excited to offer that to you. Now, okay, let us dive in, and I see the questions coming. Oops. So thank you so much for already putting your questions in the Q&A panel, and I'll try to get to these legal questions after my deck, but I do want to present on the topic at hand, which is compliance in this administration. So depending on how many questions there are, we're set for an hour. I'll try to go through my slides in maybe 20 minutes or so, and then we should have ample time for any questions, but feel free to ask questions as they may come up throughout this presentation. Okay, so let's see. First of all, super important, this changed as of like the first week of President Trump's this administration. Anybody who is not a US citizen should always carry proof of their immigration status with them at all times moving forward. And this, ideally, if you have a green card, should be your actual green card, because you are required by law to keep your green card on you at all times. It might be sufficient if you carried like a laminated plastic photocopy. You could have it as your screensaver on your iPhone, but you should have your details pretty readily deployable in case anybody ever asks you. I get it that some people don't want to have their real green cards on them because they're worried about losing it, but the law says you're supposed to, so please keep that in mind. Now, if you are here on a visa and you don't have a green card, that is okay. What you need to do is you either need to have your most recent I-94 approval notice with you or your work permit with you. That's your employment authorization document. And that will serve as proof that you're lawfully in the US, you entered with inspection, and you're currently maintaining your status. I put out a social media video a few weeks ago where I suggested that, if you have, because you have all of these things, right? You have your passport biographic page, you have your most recent visa, you have your most recent I-797 approval notice that may or may not have an I-94 on it. You have your most recent I-94. So, one option is to like Photoshop scans of all of these things onto a sheet of paper, print it double-sided, fold it up, carry it in your wallet. But you should have proof with you at all times. That's the reality that we're living in now. And, some people ask like, oh, but I'm just, can't I just fly with my driver's license from San Francisco to Las Vegas? Like, technically you can, but you should keep these documents with you at all times when you are physically in the United States. So leaving home in California and spending a few days in Vegas, you should still have them with you. So at all times means at all times. So this actually isn't a big change in the law. These laws have been on the books for decades, but nobody was enforcing them. So now they're being enforced. So now it's very important. So just make sure that you always have that handy in case you're asked. There have been lots of, of tales in the news media about people getting arrested and detained, either properly or improperly, but part of that risk could be mitigated by having these documents on you. Okay, so yeah, and somebody asked, should I take the documents even to grocery stores and gyms? Yes, at all times, at all times. That's why I'm like, how do we get this into your phone? Because a lot of people don't have a physical wallet that they carry anymore. So I'm like, maybe you get one of those card holder phone cases and you put this on a sheet of paper that you fold up and you put it in the card slot, or maybe you print it as a card for yourself. But like, yes, you could be like, if you're sitting on a park bench, if you're in a grocery store parking lot and somebody asks you for your documents, if you're at the gym, okay, if you're at the gym, maybe it's okay to have it in your locker when you're on the treadmill, but like, if you're in the gym parking lot, like when somebody's questioning you, you want to be able to present the evidence. I know it's super annoying, and that's why I was suggesting, maybe if it's like the screensaver of your phone, but then on the other hand, if somebody steals your phone, do you want them to have your identity? Maybe not, but you don't want to be like fishing around on your unlocked phone for a long time if you're being questioned either. So things to think about. I don't have the right solution yet, but I think it depends on what your status is, how many documents you have as well, and your wallet and purse preferences. So there we go. Okay, now moving on to the changing landscape of business immigration, the current immigration climate. Okay, it's interesting. It's never a dull moment. There's always new opportunities to learn new things. This is me having a positive attitude. So this is super critical, probably for everybody on this webinar, and that's why you're here, but this matters for anybody hiring immigrants, and it matters for any immigrants, any aspiring immigrants. It matters for international entrepreneurs. And, really we have a US immigration law system that authorizes immigration. It says, here are the categories. These are the people who can come in. This is how you qualify. This is what you need. So we still have the same system. We are open for immigration. It is functioning. But, with what you see in the media, you might not know that. But immigration is really crucial for people, both for your personal life, if you're the immigrant, for scaling your company and having the most brilliant talent available to you, having a diverse talent pool, and to just have that freedom, peace of mind, and security to make informed decisions about how you're going to grow your business and how you're going to navigate your future. So super important. Now, the visa itself and the pathway itself, this is like the core fundamental part of the services that we offer is the consultation phase with a potential new client. And currently, we've been having to charge for consultations because we've had a lot of demand for our services, and I only have so many hours in the day. But obviously, I'm trying to scale that because my goal would be to just solve immigration for you and make it super easy so you don't need to ever worry about it again. Anyway, most of what I do on the potential new client consultations, which historically mostly have been complimentary, are selecting the proper pathway, determining the strategy. It's like if you had a foot issue, right? Like your toe hurt and you went to the doctor and you said to the doctor, cut off my toe. And then the doctor said, well, you just need physical therapy for how you walk because your hip is funky. Go to a chiropractor or something. Would you have wanted the doctor to cut off your toe? No. So like a lot of people come to us and they're like, give me an H-1B. And they might be right, but we always start with that analysis to determine what's the right strategy. And let's start. I wrote a book. It's called Ask Sophie, the Founder's Guide to Visas and Green Cards. It's available on Amazon and Audible. I recorded the audiobook. But one of the messages in there is let's start with the end in mind. Like we can't solve for you to reach your goals for your company, your employee, or yourself until we know what your goals are. And then we have to figure out, okay, where are we now? Where do we want to be? And what are all the routes to get there? And then we have to analyze which are best, which ones achieve your goals most seamlessly and meet your requirements, which ones mitigate risk the most. How do we use the one thing philosophy, right? To just do the one necessary thing that makes everything else easier or unnecessary? How do we have the simplest, smoothest path forward, right? There's that Navy SEAL thing that people in startups talk about of slow is smooth and smooth is fast, right? So we have to utilize all of these tools to maximize your chances and effectuate the correct strategy, but it starts with knowing your goals and determining the right strategy. So the impact of proper visa selection is crucial. So we want to make sure that we're doing the right thing. And then we have to keep you compliant with US immigration laws and regulations, ensuring that the company is protected and the immigrant beneficiary is protected and that everybody can simply proceed the work they want to do. All right. So some of the key areas that the current administration is focusing on, one of them is the I-9 verification and the E-Verify process. So it is so important, and most HR systems manage this right now, but it's so important to timely complete the I-9 for all new hires. Usually if you onboard somebody into an electronic payroll system, this will just be part of day one onboarding. It's all automated, it's all electronic, it's no big deal. But if you have an older company or a company that has been doing things manually, now is definitely the time to audit your old I-9 forms and make sure that everybody's have been completed properly and that everybody who's working there has the right I-9 and that their I-9 is matching their current work authorization status. If you're in HR, anytime somebody's immigration status is expiring or changing, you need to update the I-9 accordingly. Now, in order to do the I-9 appropriately, you need to go through that proper review process, verify the person's identity documents, the work documents. Usually for immigrants, there's two separate things, like your identity could be your passport and your work authorization could be your I-797 approval notice with the associated I-94 on it for your change of status to a new non-immigrant visa classification. So there's extensive guidance in the I-9 policy handbook on how to do that. There is a very proper way to correct mistakes. So if you do have old paper records or if you do find mistakes, definitely consult us for legal advice before just trying to change the documents or fix the documents yourself. Any changes need to be super clear what you're changing. And then E-Verify. E-Verify is a program where you check if somebody's identity and work authorization documents are legit prior to them starting with you, and that process is required to hire people on STEM OPT. That's the only visa classification that requires it right now. But the thing about E-Verify that some people don't realize is once you're in the system, you have to use the system consistently for all new hires. You can't have favoritism or only use it for the immigrant, but not for the other people. Once you're in the system, you're in the system, or you have to completely leave the E-Verify system and you have to use it for all your new hires from that point forward. So that's a very important thing for compliance to keep in mind as your company grows. Now, when it comes to visa sponsorship and managing your employees, it's important to have a visa strategy. But the type of strategy you need and how consistent and how extensive it is really depends on your company, its stage of corporate development, your number of employees, your growth plans. You know, if you're an early stage company that just went through YC and you've got a couple of immigrant founders and mostly you're going to use contractors and APIs to build your company, we might just have to solve immigration for the founders manually, right? You might not need to figure out a corporate immigration policy until like post Series A, perhaps, if you're scaling. If you're an established company, you might have a policy that became more restrictive in the last couple of years because of the way the economy is and the end of the ZERP era and all of the layoffs that have been going on. So historically, you might have said, well, we're not going to sponsor a green card until XYZ milestone, or we only consider candidates with these immigration statuses, although you have to be really careful about how you do that because you can't do national origin discrimination. So as the economy picks up, we might get back to a place where having a more nuanced immigration hiring policy is helpful. There have been times where my clients have scaled back their green card sponsorship milestone to be 1 year of employment, or even just immediately after the H-1B is selected in the lottery, they would start the perm green card process. Sometimes companies have had to make exceptions if somebody is going to be maxing out on their 6 years of H-1B and they really need to get the perm or the I-140 going right away. That might be room to sponsor somebody for a green card earlier than you otherwise would. So these things are all reflective of economics, hiring plans, company scale. If you have a dedicated HR manager yet, or if your COO or your CFO or your CEO is the one who's handling immigration, or the chief of staff to the CEO, can be, it's not a one size fits all thing. So whoever that point person is, as they assess candidates for visa eligibility, maybe you have a recruiter, right? We work a lot with tech recruiters on scanning candidates and helping them get onboarded and having the immigration be part of their onboarding process. But whoever's in charge of that in your company, they need to be responsible for ensuring that all of the visa petitions have been prepared accurately, working with us to ensure that all of the visa expiration dates are being managed and that we're filing the extensions on time, and maintaining public access folders for H-1B cases, H-1B1s for people from Chile and Singapore, and E3 visas for people from Australia. So when it comes to immigration enforcement, we are expecting certain changes to happen. So the Biden administration actually paved the way for the Trump administration to be able to engage in increased workplace audits and inspections, and that's through the H-1B modernization rule which took effect on January 17th of this year. And that was kind of an interesting strategy play by the Democrats. They wanted to streamline H-1B adjudication and make it easier and more clear to determine how somebody would qualify for an H-1B job and have it be more focused on, okay, do the classes they took for their degree match up with the job duties that are being required for this job to make sure there's a match. But in order to get some of those proactive immigration, streamlining, ease things through, they kind of like paired it with a bunch of increased compliance, increased site visit language, because they also wanted to make sure that this rule would not get overturned through the congressional, it's called the CRA. It's where Congress could vote to repeal a last minute regulation from the prior administration. But if they do that, then they're not allowed to add a new regulation on the same topic. So by having a lot of stuff about site visits and increased enforcements in that rule, it has meant that this administration has not yet chosen to try to attack that rule, because if they did, they wouldn't be allowed to do as much enforcement or site visits. So it's kind of this like legal strategy thing that was happening. So there is this option, and we are seeing some increased workplace audits and inspections and stricter compliance requirements. If you have a company, you should be prepared that you could be audited at any time if you've done immigration in the past. And that could mean a written audit, that could mean somebody calling your WeWork to see if you really have an office there. It could be an inspector visiting and asking for an H-1B public access folder. And theoretically, if you are working from home, you could have a person audit your homework site as well if you're the beneficiary. So you just need to be aware that that could happen. And the other thing that we're seeing is this enhanced scrutiny of visa applications and petitions. So far, knock on wood, we have actually been maintaining our like I think 96, 97% approval rating, and we have a consistent RFE rating, or consistent rate of RFEs compared to the Biden administration. We actually haven't seen it change with increased scrutiny of visa petitions at this point in time. But where we are seeing some increased scrutiny is for our clients who are going for consular interviews to do their visa stamping and who are coming in through the border or the airport. So at this time, we are cautioning that if you are a foreign national currently in the United States, we would prefer if you could restrict any travel to only essential international travel, because there's just too many reports and stories about people who went out but who have been gotten 221G visa refusal letters, or placed in administrative processing, or had issues at the airport. So now is not the time for a fun international vacation. Now would be the time, if you really need a vacation, to go to Hawaii or Florida or see other parts of the United States. But obviously, sometimes people have to travel, and for the most part, our clients' travel is still going smoothly. I just don't want anybody to risk something if it's not essential. And the other thing to really just reinforce is the importance of being proactive. So by being proactive, we can mitigate any legal risks or any financial risks. We can maintain business continuity, help protect your company reputation. It's really important. And the other thing that you can do in advance to be proactive is to designate a point person for your company for site visits in case there ever is an in-person audit or inspection from the immigration enforcement side. The other thing that's really helpful is just in general to foster a culture of compliance in your company. So that involves establishing protocols, having robust processes for form completion and storage, engaging in regular internal audits, and training hiring managers on proper procedures. And that involves both how do we put out proper job ads, how do we screen candidates properly, how do we work with our immigration law team to make sure everybody's maintaining their status. If we're doing an LCA, are we doing the posting correctly? do we have the public access folders organized? If we're doing the perm process, are we screening those candidates properly? So there's a number of steps where your immigration lawyer can't do everything for the company. We need that company point of contact to be available if they don't already know how to do these things, to learn, to be able to help build up your company's immigration program and maintain it properly. Now, and then all of that applies for E-Verify as well. Okay, so from the visa point of view, for all of these non-immigrant visa categories like H-1B, L-1, E-3, TN, F-1 OPT, regular OPT, just be aware that there could be changes to these categories. There shouldn't be too many. If changes do happen, they should go according to the regulatory process of the APA, the Administrative Procedures Act. Usually there's supposed to be warning on new changes. So we might be seeing new regulations coming over the next several months, but we would have lots of notice to be able to deal with them. There's another thing though, where, H-1B season registration ends on Monday. So we will be seeing usually by the end of April who gets selected. And then those companies have April, May, and June to file the H-1B petitions for those candidates. So we're going to expect a new wave of H-1B adjudications happening starting in April and probably going through the end of the summer. And 8 years ago, that's when there was a lot of scrutiny on the H-1B computer programmer job role, where just overnight they had a change in the administration. Suddenly everybody with a computer programmer job, SOC code, got an RFE. Most of those cases were denied, and that was never proactively announced. They just overnight changed the standards. And this happened, so all of that could happen again with H-1B season this year. So we might just still be in that like eye of the storm honeymoon period where we're like, oh, we're still fine, who knows? So we're keeping a close eye on that. But another recent example of something similar was last week, 2 weeks ago on Tuesday, we came in and all of a sudden there had been an announcement that effective that morning, there was a new required version for all I-485 adjustment of status forms, and anybody who hadn't filed would be rejected. We had several clients where we had like overnighted on Friday their adjustments to arrive on Monday, and we were hoping that since it arrived Monday and not Tuesday, those clients' cases would be would proceed. But so ultimately what ended up happening over the last 2 weeks is a lawyer sued, a judge issued a temporary, I think either a temporary restraining order or an injunction, and the government has now been forced to utilize the old version of the form as well for several more weeks. But people's cases did get rejected, even though it was illegal. And so they are having to refile. So this is the sort of thing where like, we can do everything perfectly, but if the day that UPS delivers your package to the government, they have arbitrarily decided to change the rules that morning, we can't control every single part of the universe, although I wish we could. But we can try to mitigate risk. That's what we're doing. We're trying to mitigate risk and make your case as strong as possible and help you put your best foot forward. Now, we also have to be aware that there could be longer processing times ahead and the possibility of increased requests for evidence. So if there are longer processing times, that means filing earlier becomes more important. Trying to get the approval before the end for an extension before the end of the current status becomes important, instead of filing at the last minute and hoping for the approval into the new approval period. And then just knowing that RFEs could increase, and we'll deal with it and we'll figure it out if and when it happens. Also, I know we have a lot of human resources folks and people ops folks on this call. So communicating your support to employees and keeping them aware of what's going on is also really important. So this could be an internal newsletter, a meeting announcement, a lot of people are concerned about their status. And so just communicating, look, here's our immigration strategy. We're aware of the situation. We want to keep you all protected. You can always reach out to this person if you have any questions about your immediate status, but our protocol is to, and like what we do at Alcorn is we're now reaching out 9 months in advance of an expiration to be able to tell people, hey, would you like to do this? And in a lot of cases, we can't even file until 6 months before the expiration, but we still really want to get out ahead of it. So letting people know that A, you're aware this is an issue for people, B, you care, and C, they can ask you any questions. Even just that goes a really long way. In terms of the travel restrictions, so it is also important to educate your employees on potential travel risks, as we might be having a new travel ban soon. And I'll talk in the next slide more specifically about what those bans could look like. But really for businesses, eliminating any non-essential business travel for your foreign national employees, I think is very, very important. Pre-travel briefings, advising your employees on what they might expect when they leave and when they come back in. It's very important. Providing people with recent HR should provide people with recent employment verification letters, and foreign nationals should bring 3 recent pay stubs whenever they're leaving and coming back into the country. Just having that protocol so that everybody's prepared with all the documents is very important. Renewing your passport early, making sure your visa is valid, and being prepared for these travel bans that might happen soon. And I don't know if they're going to happen. There's been speculation, there were drafts leaked within the last week, but the State Department is still saying they're not sure if they're actually going to be doing it. But keep this in mind, and we'll talk about what that is next, but you want to monitor specific countries' restrictions. You want to develop contingency plans for key projects. You want to consider alternatives to international travel, like this thing called Zoom, that some people are using now, which isn't great for everything, I realize. And also to have emergency communication protocols. There's an article this morning in The Independent, which is a expose of a woman from Canada who was just detained for almost 2 weeks when she entered into the US on her TN at the San Diego border. And her attorney went nuts trying to locate her. Her cell phone was confiscated. She memorized the number of one friend, but wasn't able to get through. And then at some point, she remembered her boss's email at her company, and they ultimately got an email through to her boss somehow, who was able to connect with her lawyer, and eventually she was freed. And she wrote a really, she wrote about her journey, and if you're interested, I would encourage you to read it. It's in the, I think it's in the Independent or the Guardian today. So that's the type of thing where you want an emergency communication protocol, and you want to minimize unnecessary international travel. Okay, so now here is the draft for what might be happening in the coming weeks. And it is different compared to the Trump 1.0 travel ban, which was called the Muslim ban, and it was litigated up to the Supreme Court and back down several times. Ultimately, some version of it stuck. But what we're looking at now, which might come out, gosh, in 2 days, potentially, we'll see, but there are 43 countries being considered. It's a more expanded version than the first travel ban. We're actively monitoring this situation, but the way this one is styled, at least in the draft, is it would have 3 tiers. So some countries would be in the red category, some would be orange, some would be yellow. And it matters if you're a citizen of these countries, theoretically. Now, the red category would be 11 countries that have a complete ban. So that would mean that no citizens of Afghanistan, Syria, Iran, North Korea, and several others could come into the United States. Notably, India and China are not on any of these lists. The orange category, these individuals would face significant restrictions, and everybody would have to go to an in-person visa interview. That includes Pakistan and Russia. And then the yellow category is 22 countries, mostly in Africa, who would have to improve their vetting procedures, or else they could face consequences and go to orange or red. So that is the most recent draft. But I don't know if that's ultimately what's going to happen or if anything will happen. But if you are a citizen of any of these countries, definitely go check it out for more details. If you are outside of the US, you might not be able to come into the US very easily anymore, including if your H-1B gets selected in this H-1B season. If you're physically in the US right now, I would say just figure out how to stay here. Don't travel internationally. Let's just do changes of status for you, extensions of status for you. It's not worth departing at this point. So with all of this, I encourage you to stay informed and be proactive and stay agile. I interviewed this brilliant futurist on my podcast, and he had a phrase called VUCA to describe the world that we're living in. And VUCA stands for volatility, uncertainty, complexity, and ambiguity. And that is the type of world that we're living in. And knowing that that's the type of world that we're living in allows us to know what strategies we need to use. So we need agile strategies, right? We have to stay nimble, flexible, curious, creative. We have to be focused on our actual goals. And then we have to, constantly look at the playing field to figure out how we're going to get there from here, because there is a way. There's plenty of legal pathways open for immigration, and there's a way to do it all correctly and be fine with this. So you're welcome to keep in touch. We have lots of newsletters that we send out at least 2 times a month on all the latest immigration updates, all our social media. I do videos, podcasts, all of that, LinkedIn, Twitter, et cetera, et cetera. We are available for consultations, and we're expanding that capacity in the coming weeks and months. Definitely, attend industry events and webinars. You can subscribe to email updates from U.S. Citizenship and Immigration Services and the Department of Labor. And as companies, you really want to continually update your policies and procedures to ensure you're staying compliant. We offer a variety of solutions, and I can talk more about this in the questions. But Alcorn Academy, my online class, is now complimentary. Over 1,000 people have taken it, and that has allowed them to become qualified for O1 visas, EB-1A green cards, and EB-2 national interest waiver green cards, which are primarily self-petitioned, but not necessarily. Now, in Alcorn Academy, one thing that I will just say about that is, over the last year, people started following this pattern of evidence to try to get EB-1As approved. And those very typical types of evidence that you can read about online are now facing a great deal of scrutiny and requests for evidence. So one of the ways I tried to record Alcorn Academy in 2020 was to make it evergreen based on how the law actually is, not based on fads of the moment with which regarding which types of evidence are popular. So the content of that is still quite applicable today. And the way I designed the curriculum was to help you be able to think creatively in your own field of expertise about how to become qualified. And I just put that link in the chat window. We also have another service I'd like to share, which is called Legal Launch. This is the quickest way we can help people right now on these types of cases. It's a 4-week assessment and evaluation program where we give you our 20-page checklist. You have a series of 4 meetings with our team. We do a 3-layer internal strategy case review, and ultimately it culminates in a attorney case strategy meeting where we either tell you, yeah, you can apply now for an EB-1A, O1A, or EB-2 and AW, and we'll fully credit the $2,500 service fee. Or, hey, we think you can become qualified. Here's your gap analysis. Here's your personal roadmap for the types of things you need to do in the coming months to be able to have a stronger petition. And then we credit those funds to the future visa within 6 months. We offer a variety of cases. We help a lot of companies. We're there's been a lot of change up in which companies are using which counsel, and we're actively welcoming and onboarding new corporations to help with their international teams in the US. So happy to offer those services as well. Now, if somebody reaches out to us for a consultation, you'll get an extensive questionnaire. We've tried to make it as simple as possible, but the person needing immigration services should check as many of these boxes as possible that apply. This helps us figure out the right strategy and the right visa classification. Okay, and now we're going to be going to questions. Thank you for those. I'm going to leave out my contact information a few more minutes, and I will go to the Q&A panel. And just some other points I wanted to mention. I said this at the beginning, but yes, this is recorded and we will be sharing the recording with everybody. Okay, let's go to the questions. I have a valid H-1B visa stamp and my I-140 approved, but I'm outside the US and I don't have an active 797. If I apply for an H-1B as a startup founder, would it be cap exempt? Do I need to get a new H-1B visa stamp, or can I travel back to the US with the existing visa stamp? You can apply for an H-1B as a startup founder if you have a qualifying company. That takes a consultation for me to learn about your business plan and your corporate setup so we can make sure that your company is qualified. I usually break down the service of an H-1B for a startup founder into a consulting portion and then the actual H-1B transfer portion. So we would be targeting getting you an 18-month I-797 approval. With that in hand, you would be able to use your existing H-1B visa stamp plus the new I-797 approval notice to travel back to the United States. So you're welcome to reach out for us for a consultation, and we're happy to help with that. Next one. If I'm about to receive a job offer under F1 OPT, but the employer is not in a position to sponsor an H-1B, can I apply for an H-1B through my own startup's LLC? Yes. If selected, can I file for a part-time H-1B for 5 hours a week while simultaneously working full-time 40 hours per week for another company on F1 STEM OPT? No. So you can only have one status at a time. So you're either completely an F1 person or you're a person who's completely an H-1B. You can have 2 jobs in STEM OPT. You can have 2 jobs in an H-1B. But if you're doing 2 STEM OPT jobs, both jobs need a training plan and to be enrolled in E-Verify. If you're doing 2 H-1B jobs, both jobs need H-1Bs and both jobs need to pay you the prevailing wage. So you have to pick one or the other. So if your startup's H-1B gets selected and gets approved for the October 1st start date, then you would want your employer who didn't put you in the lottery to file a second concurrent H-1B to start on October 1st. And hopefully knowing that you've already been selected will, mitigate some of their fears about sponsorship because they don't have to deal with the randomness of the lottery at that point. What are the current risks involved for H-1B visa holders that are from countries on the yellow ban list, which would like to visit their home country between May and June? Let's find out. The way this draft was written, if you have a valid visa in your passport and you're on the yellow ban list, you might be able to travel in May and June. But if your country is moved to the orange list, then if you need a new visa, you would have to go for an interview. You can't do a Dropbox situation. And if your country is moved to the red list, when you're outside of the US, you can't get back in. So I would potentially urge you to not travel in May and June until it's clear if your country is definitely on or off the red list, because that's the one that could prevent you from getting back in if those lists stay the same as drafted. How long can a startup be considered a startup, and how long can a founder contribute to the setup of the LLC? The LLC was created in 2024, but nothing was done for the setup. For example, website creation, payroll setup, etc. Is the founder still able to set up in 2025 and not be considered working for the LLC and violating their visa? It's creating your website for your LLC. Consider working for the LLC, not your H-1B sponsoring company. Well, there's no definition of a startup in immigration law. So there's that. It's not a legally defined term that has any meaning. So we have to look for the answers elsewhere within the law to answer your questions. If somebody just owns an LLC that was created in 2024 and nothing happened in it, it's completely fine. If you want to get your company set up to do something active in the business, like if the business is going to have revenue or you're going to hire employees in 2025, then we ought to have a consultation to figure out what exactly you need to do, how to minimize any time of uncertainty where you're either, because you have to do some things to get the company to exist before you could do an H-1B that's concurrent or a transfer. But I think that, creating your website, that could have a variety of subtopics. I think that if your company is a technology product and the website is the product, essentially, then you should be very cautious about creating the website in the situation you're in. If you just need a landing page to direct people to some services, maybe the business owner could hire a gig worker to create a website for them, thus, minimizing any risk of engaging in rendering services for which there is a hope of future remuneration, which is kind of the definition of employment in immigration law. What are the qualifications for startups to sponsor work visas? If one of the co-founders is holding a student visa while another co-founder is a permanent resident, what is the most suitable legal entity for this case? Okay. So in immigration law, there's a variety of those pathways and categories, and the company and the person needing immigration support have to make sure that they are matching one of those categories and the work that is to be performed is matching one of those categories. So in this situation, probably the co-founder permanent resident might end up signing the paperwork to sponsor the student co-founder to work at the company. Often what this looks like for a startup, which is not for immigration reasons, it's for venture capital reasons, is that the founders incorporate a Delaware C corporation. And if they're in San Francisco, for example, they would register their business with the California Secretary of State as a foreign entity to be able to do business in California, get a bank account set up, get an FEIN number. And then the company would be ready to sponsor H-1Bs, OPT, STEM OPT, O-1 visas. Those are the most common visa types in this type of situation, but would be super happy to have a consultation with you all for that. Can F2 visa holders currently in the USA put their name in the H-1B registration? The earliest possible start date if you get selected is October 1st, but if you have a company in the US willing to offer you a job to start October 1st, we could set up a change of status from F2 to H-1B through the lottery. Will premium processing the O-1 visa processing time? Well, okay, I'm just going to restate this. The O-1 visa processing time is 15 business days if you pay for premium processing, and this person's wondering if that could change. The government doesn't have to adjudicate the petition in the 15 business days. They have to either adjudicate the decision or provide a refund of the premium processing fee, which would be $2,805 for an O-1. So what we saw in December for EB-1A was that there were so many cases that many of them still have not been adjudicated. We're getting several approvals for, every week, many approvals for EB-1A cases we filed in December with premium processing, where we were supposed to get an answer before President Trump took office on January 20th, but that didn't happen. But now our clients are getting refunds. So I have not seen a similar type of stagnation in the O-1 adjudication, but that's not to say it couldn't happen in the future. A few more minutes. I'm not going to be able to answer all the questions we have today, but I'll try to get to a few more lightning round. Is EB2 impacted by Gold Card? No. I invest and build startups with around $2 million of investment and lots of granted patents coming to the USA. That's amazing. Would love to help you. Reach out. So far, we don't have any real details on the Gold Card yet, but we're monitoring that because I would love to be able to offer those. Can someone outside the US, but part of the company HR team, be a point of contact for the H-1B registration? Yes, one of our companies has their human resources person in Spain. Another one has their human resources person in New Zealand. So you can absolutely do that. Thank you so much. And then, how can remote companies with no physical office comply with H-1B site audits? You have to have the materials in the work location where the beneficiary will be working. So if they're working from home, they need that information with them at home in case they're ever audited. Do naturalized citizens need to denounce their previous citizenship if they're from the banned country list? One of my best friends is an immigration lawyer who was a refugee from Iran as a kid, and that person is a US citizen, but technically still theoretically might hold an Iranian citizenship. She is concerned about traveling internationally right now because this is a legal issue that has not yet been resolved. So the safe thing would be to renounce a prior citizenship, but I don't know what your country is or what process they would have or how accessible it is. So I would say this is an area where we're staying tuned for more details. Can fully remote companies qualify for sponsoring the H-1B? Yes. Can a founder holding 50% of the equity of a Delaware C Corp on OPT apply for an H-1B without funding and revenue? Yeah. If not, what are the necessary conditions right now? The conditions are that by October 1st, if selected, the company would be able to pay you the prevailing wage. And throughout the H-1B preparation process over the next 3 months, we would need to prove how that revenue is going to come, either through investors or letters of intent or various other ways of funding. So it might be worth taking advantage of this year's H-1B cap registration, which closes on Monday. Can an H-1B holder work for their LLC, not their sponsoring company, while outside the US? Absolutely. When you're outside the US, there is no jurisdiction or control over you by US immigration law. You can be free and do whatever you want. And then, are there any, last question, are there any immigration legal requirements needed if a company changes from a multi-member LLC to a single member LLC? I don't know. I don't think so, but maybe reach out because it really depends on if the person's job is changing, not really if the company is changing. And then if a company is not funded, it can't pay the prevailing wage, so it won't be possible to apply for the H-1B without paying the prevailing wage. The company has to pay the prevailing wage. There's various ways to get money. You can raise money from investors. There can be a loan to the company. There can be revenue from selling a product or services. So that is what you would need to line up to be able to pay the prevailing wage. But the prevailing wage does need to be paid for. Okay. Well, that is it, everybody. Thank you so much for staying with me. You were with me until the very end. I appreciate it. You'll be hearing from us at Alcorn. We would love to keep in touch. Thank you so much for your support. And for any more questions, definitely reach out to us, hello@alcorn.law, or through our website. We would be delighted to support you. And I'll be in touch as there's further updates. Thank you, everybody. Have a great day. Bye.